Thank you for joining us today. My name is Furchtgott-Roth, and I'm a senior fellow at the Hudson Institute and head of the Center for the Economics of the Internet. Everyone who is watching this speech is doing so voluntarily. No government compels you to listen. No government forbids you to listen. Neither the speaker nor the content was selected by any government. If you are the parent of school-age children, your children may also watch speeches, some over broadband from home or in person at school. If your children do not watch, both you and they may be punished by the state. And in many instances, the state selects both the content of the speech as well as the speaker. Professor Hamburger will explain why education is a form of speech. This is such a self-evident observation that few, if any, scholars before Professor Hamburger have noted it or explored the consequences. And the constitutional consequences of education as speech are troubling, particularly for parents, and particularly for the vast majority of parents who have no economically feasible choice but to send their children to public schools. Philip Hamburger is the Maurice and Hilda Friedman Professor of Law at the Columbia Law School. He is a scholar of constitutional law and its history. Before coming to Columbia, he was the John P. Wilson Professor at the University of Chicago Law School. Professor Hamburger's contributions are unrivaled by any U.S. legal scholar in driving the national conversations on the First Amendment and the separation of church and state and on administrative power. He is the founder and president of the New Civil Liberties Alliance, the leading First Amendment thought center in America, and he is the author of Is Administrative Law Unlawful?, the most influential book on administrative law in a generation. It's a great honor to have you with us today, Professor Hamburger, and we look forward to your comments.
Well, thank you. It's great to be here. It's very kind of you to have me on this show. And it is an interesting topic, and it's long puzzled me and slowly beginning to sort itself out in my mind. So I'm glad to be able to talk about this. We all experience school. I don't know whether you liked it as a child. Did you like school? Were you?
Depending on the class. Some I liked and some not so.
Right. Some was part of it was exhilarating, and part of it was intensely not pleasant. And I think I tried out more schools than most people. I think it was a new school every year, and of course, therefore it varied. But one thing that was consistent was much of it was not what I wanted, not what my parents wanted. And now as a parent, of course, I feel that doubly so. Right, so the recent upheavals in education, where parents actually get to see, because of COVID, what's being taught to their kids on Zoom, are interesting. But I want to begin by pointing out, I don't think we should focus simply on concerns about, critical race theory and the rest, because as we both know, these disputes about education have been going on for a long time. This is just the latest iteration of the disturbances that parents feel when government tries to impose education on their kids. And the gist of what I want to argue is simply education is speech. We don't normally think of it that way. We have it's its own separate power of the state to impose upon one. But it turns out, if you think about it, how much is not speech? Even athletics, much of it is speech, and certainly a lot of it is expressive conduct. In science, there are physical experiments that are not speech, but it is probably expressive conduct. And of course, you can't do any of these things without the core being speech, rather than instruction or hypothesis or one's reading assignments. And certainly in the core of education, it's just speech. So that's unsettling, right? Because suddenly when one sees that, when all sorts of things become clear, we have a lot of doctrine on speech, as we both know, very clear Supreme Court doctrine, not perfectly clear, but clear enough, much clearer than a lot of our other modes of analysis. So perhaps we should talk a little about the traditional modes of analysis here, right? When people talk about education or parental rights, often they go back to a case called Pierce versus Society of Sisters. The Scottish Rite Masons, Southern jurisdiction, together with the Ku Klux Klan, worked with the Democratic Party in Oregon to impose compulsory education Needless to say, this unsettled a lot of parents and, of course, Catholic schools, which would be put out of business by this. And the Society of Sisters, which had such a school, fought back with the support of the Hill Military Academy. And they won a Supreme Court case in Pierce versus Society of Sisters in 1925, in which the Supreme Court makes quite clear that compulsory education, public education, is unlawful. What's most unclear is, A, what's the foundation for that? They treat it as some sort of substantive due process right, which means nothing that's actually enumerated, but it's somehow in the due process clause. And because of that uncertain foundation, it also has an unclear extent. They don't really address how much regulation of private education there can be. It's just you can't be forced into public school. And because of that heritage, which mostly arose, I think, because the case rose, it wasn't a parent objecting, it was a business, a school, and no profit there, but still a school objecting. It was treated as a substantive process semi-economic right. So we've never really considered in the courts the possibility of a speech right. And when you think about the parents' interest in all this, it's education is speech, it's the parents' speech to their children. In any case, that's the fact. So that's a new angle on this. And I think it gives us much greater foundation in the Constitution, much greater clarity than anything coming out of these old Supreme Court cases.
It's great. Tell us a bit about the history of public education. When the Constitution was written, was there public education in America? And if not, when and how did it evolve?
Right. It's interesting, these folks who framed our Constitution, whether Southerners, Jefferson, Madison, or Northerners who were involved in the setting up of the government, from my home state, Connecticut, their education didn't look like ours. And I think in retrospect, I think modern educators would say they had terrible education, not much, and yet somehow they managed to do some remarkable things, which I think should lead us to question our expectations about education. So most education at the time was done at home. And if you're lucky, let's say you're in a New England town, there's a chance there'd be a town school, which would just be a one-room shack. And the teaching there typically was not done by professional staff. On the contrary, most of the teaching in New England is done by the established ministers, Congregationalist ministers, who did this mostly on the side. The kids would come in and they'd be instructed in religion, reading and writing, a little math. That was the education of our founders in the best of circumstances. In the South, there's much less of this, if any, and the wealthy had private tutors. So they didn't have an educational establishment. And although some of it was semi-public in the towns and required, much of it's done just on the initiative of it depends entirely on the initiative really of local clergy and a few others in town who want to help make it work. So they didn't have it. They had something much more modest.
So today we have public education in every state. How does that develop? And when does it develop?
Yeah, right. So there's this funny story here, which no one really wants to know because it's somewhat indigestible from an elevated constitutional point of view. So the danger that provokes most of this is the influx of Irish Catholics in large numbers to urban areas, but also, the Irish Catholics end up, in rural Kentucky too. It's all over. There are a lot of folks fleeing Ireland. There's a much better set of opportunities here, but the opportunity that's missing here is an egalitarian spirit towards the newcomers. Many Protestants are quite upset by the Catholicism of these folks. There's also class prejudice, of course, because essentially a peasantry just hardly removed from peasant conditions in Ireland is now coming to egalitarian America, and that rubs a lot of people the wrong way. So many states begin to develop public education, common schools. So we get Horace Mann and others. And although it's all stated in highly genteel, elevated ways, the real goal is to get the execrable Irish to be civilized, to be more Protestant. And the attempt to Protestantize them is often quite explicit, and of course leads to some riotous conditions in some cities. It's not very nice. It's a form of force. It's a form of religious and civic indoctrination. And of course, the real goal is to get them to vote like Protestants. It's not just about their souls. So it's charming, isn't it?
This is the 1840s and 50s.
There are hints of this earlier, but it really takes off in the 40s and 50s. And of course, we shouldn't kid ourselves. Government has an interest in education. Government, there are good reasons for wanting educated citizenry, but we should not. That doesn't mean we necessarily have to have government-imposed education or the homogenization that was quite deliberate in all of this. And we should also remember those founders you alluded to. 17th century New England, men and women had extraordinarily high rates of literacy, among the highest in the world. And they did not have an educational establishment. What they had was religion and a certain discipline that came with that. So it's worth remembering that much of this is not necessary for the alleged ends, but it is necessary to indoctrinate a class that's viewed with some disdain.
I remember seeing somewhere in the past year or so some statistics on literacy and just how rare literacy was in the world, really until the 19th century. Actually, what becomes the United States was an exception to that. I think we actually had a higher literacy rate than much of Europe at the time. But what you're telling us is that the concept of compulsory education really doesn't come about until 1840s or so, and that's in response to Irish immigration.
Well,
is it primarily an urban concept? Because right. Do people on farms have compulsory education at that time?
Well, let's distinguish between compulsory education and compulsory state education, and what the pressure to go into state education, right? So there's compulsory education already in 17th century Massachusetts. But it's not about but it's about religious schools, which may have been rather better than some of our state schools. And although they were much more modest in their ambitions, they achieved a lot. And of course, their ultimate goals were inward. Right? It's the nature of Puritanism. And whatever you think of indoctrinating folks in a particular religion, I'm not terribly in favor of that, of course. The inwardness of Puritanism paid off in a way that a lot of the outwardness in a lot of contemporary education does not. Right, so it's not just urban compulsory education, and it's not just 19th century, but the attempt to force large parts of the population, not into just local little schools, but into state-organized local schools. That's a 19th century product, and of course it's influenced by the Germans, which is a mixed blessing, as so often in education and other matters, right? Can I read a quotation just to give a sense of
course,
what was wanted here? This is from a 1904 pamphlet written by nativist, i.e. someone who identifies as a Protestant native-born American. And what he wants from public schools, and this was sort of typical, although it's unusual, it's said with distinctive aggression here. Our public school is the mill that is to grind out the standard of morality, knowledge, and patriotism to all. Our American school is like a great paper mill into which are cast all rags of all kinds and colors, but which lose their special identity and come out white paper, having a common identity. So we want the children of the state, of whatever nationality, color, or religion, to pass through this great moral, intellectual, and patriotic mill or transforming process. And in many of these advocates of public education, both nativists and the educational establishment talk quite candidly about desiring homogenization of Americans. And whatever you think about assimilation, when the homogenization is intellectual homogenization, we have a lot to worry about.
And this quote that you just gave, so that wasn't an outlier. That was a fairly common view of public education in
Right.
the early
It's
20th
it's a,
century.
yeah, it's a standard view. It is said with a certain verve, right? Very
Yeah.
few people use metaphor that quite as hard as that. But many people are very candid that they want homogenization. So and you can find this in all sorts of places. You find it in educational tracts. You find it throughout nativist tracts. So, for example, the magazine called The New Age, which is the Masonic publication, and the Masons are very influential in a lot of this educational stuff, both amongst educators and amongst more overt nativists. They repeatedly say the goal is homogenization, to get an American citizen with the American ideals and not some of those peripheral and dubious ideals that some people have.
And throughout this, you point out there's this anti-Catholic bias.
Right. But it's not just anti-Catholic, you see, because so nativists, many people say, oh, the nativists, the Klan, they're fundamentalists. Quite the contrary. The Klan is established as a national institution in the 1920s as a theologically liberal entity, one that is dismissive of forms and formalities and is looking for common Christianity. And so it's very much opposed to any sort of distinct orthodoxy. So this is why, for example, in Michigan, Lutherans are opposed to the Klan and their efforts in public schooling and against the Scottish Rite too, because the Masons and the Klan are seeking a generic religiosity through the public schools. And of course, Lutherans have their own distinctive and distinguished tradition, and they didn't really want to give that up. They want their children to be educated as Lutherans, not as generic Christians, let alone in some sort of crude organization. So any distinct religion suffers from this. In that sense, it's theologically liberal in the broadest sense.
Were there court challenges before the Oregon case from when there was this beginning of compulsory education?
Right. So a few years earlier in Nebraska, there's a case called Meyer versus Nebraska. And Nebraska, in a high-minded fit of patriotism, decides after World War I that German is really a dangerous language, and they don't want it taught, even in private schools. Now, the German nation did cause a little bit of trouble in this past century. On the other hand, is German such a dangerous language? Isn't it good that children learn different languages? And the Supreme Court holds this statute unconstitutional, which is very important because this is an early instance of protection of speech. But this issue hasn't gone away. Earlier, Native Americans are forbidden to be taught in their native languages. It's purely a matter of speech. My interest in this arose a year or two ago when New York State went after yeshivas here in New York City, where they teach in Yiddish. Now, Yiddish isn't really my thing, and there's a lot to be said for a broad education that goes beyond what's taught in the yeshivas. But what business is it of the state of New York to dictate to schools what language they teach in? Most immigrants to this country learn English, or at least their children do, right? You don't need to be taught in English. Wouldn't it be a blessing to have children taught in German, in Yiddish, Mandarin, right?
Right.
And Latin. Why not? I would love to have our children taught in Latin. And the idea that somehow being taught another language is an offense to the state is astonishing. It's as if we're trying to inculcate a lack of sophistication and sort of bloody-minded narrowness. Who knew that that's a virtue? It's just astonishing.
Wow. Yeah, I sent my children to French language school, so they nothing but French.
Right.
Thankfully, Maryland didn't have a law against that. So New York tried to have a law. Was it just Yiddish, or was it any foreign language?
So the law generally requires substantial equivalence between private and public teaching which is itself kind of scary, both because it's oppressive and because it really would dumb down private schools, right? But they also have a language requirement. Now, this stuff didn't, the state backed off because they realized there was going to be litigation that would not be to their liking. So they backed off, which was sort of the goal of writing on the subject for me and many, many other people. But the issue hasn't gone away. It just comes up in different forms every year. And that gets, so can I lay out the legal argument here? Because the legal argument,
Let's absolutely.
it actually gets rather interesting. So there are two speech arguments relating to public schools. And I should say at the outset, the objection is, and some people have misunderstood the argument, so I want to state up front what I'm not arguing. It's not an argument against public schools. They should probably will and should survive what I'm proposing. Nor is the suggestion that judges should tell states to have vouchers or any other remedy. That's not what this is about. But this gets back to your compulsory education point. When the government says parents must educate their children, and then it offers them public education for free, should I say not public, but government education, government educational speech to be precise. What's going on here? So one analysis is that this is a direct abridgment of one's freedom of speech, because it's telling parents who can't afford to opt out, essentially you have to be in public school. You have to go to school and only the wealthy can opt out. Ain't that charming? So a few people get into a parochial school on a scholarship or something like that, but everyone else is forced in. And the pressure here is intense because, of course, it's expensive to opt out. So this is the combination of this broad generic mandate, educate, and then this narrower, oh, and here's some public education for free, really is a form of direct force. Now, there's a second argument, which is actually based even more clearly in Supreme Court precedent. Leave aside the general mandate or compulsion. The government says, here's a gift, educational gift, but there's a condition with it, which is you have to take it in a public school, which means you have to have public educational speech, government speech, not in place of your own speech. That's an unconstitutional condition. And nowhere is the doctrine on constitutional conditions better developed than as to freedom of speech. This has been on my mind because, let me just reach over here. I just published a book, I don't want to advertise, Purchasing Submission, which is precisely on conditions. And I didn't really explore this issue there because this is its own interesting world. But the notion of purchasing people's compliance creates a whole new avenue of control for government that people haven't sufficiently thought about. Well, here we actually have very good precedent. So if you ask someone what's the most important speech, the most important education precedent, perhaps the most important precedent in all of American history, it'd be Brown versus Board of Education, 1954. And most people think that what Brown was really about was about equal protection. And that is to some extent true, but that doesn't actually fully capture what happens in the case. Because what they're dealing with is public education, right? And they're saying it has to be equal. Why does it have to be equal? Because it's a benefit from government, and benefits from government cannot be offered in ways that violate a constitutional right. Let me read you a line from Brown. Such an opportunity where the state is undertaken to provide it, in other words, the state doesn't have to provide public education, but where it's undertaken to provide it, is a right which must be made available to all on equal terms. In other words, public education is a benefit. And here, it's not equal protection question so much, although perhaps in economic pressures it might be, but it's very clearly a speech condition. You give up your parental speech and substitute government speech. That's compelled speech and an abridgment of speech. And on both grounds, this is clearly an unconstitutional condition.
Are there other government benefits that are so clearly a form of speech as education, or is education a unique government benefit in that way?
You know, I've been wondering about that. If you have any suggestions, let me know.
I was just trying to think of something else, and nothing immediately comes to mind.
That's right. It's hard to understand what it is. Now, of course, education at the college and graduate level, when it offered to a public institution, That's also speech, but there the speech is being offered to the person being educated. It's not displacing someone else's speech.
And it's not compelled. You don't have to go to
That's
college.
right. And it's not compelled. So both of the arguments, the direct abridgment and the conditions argument, melt away there. This is not about that sort of thing. And notice there's not a claim that parents should control curricula or school boards. Nothing to do with that. It's simply that this is an abridgment of the freedom of speech of the grossest sort, a sort that's very dangerous because it homogenizes the people in line with government thinking. Is that the government? What's the line from Brecht that the government should dissolve the people and elect another one? That's what this is designed to do.
Has this argument been made before, or is this a novel argument that you're making?
It is, for better or worse, a novel argument, and that's a problem because it unnerves people, right? It is clearly based in the Supreme Court doctrine, but are judges going to have the stomach to live up to it? We'll see. They should. It's not only clearly based on Supreme Court doctrine, this is also a very dangerous practice, as I think people are beginning to realize. But we'll see. But yes, it is novel, and so judges, being naturally conservative in the sense of being cautious, might hesitate. But if they do hesitate too much, we've got a problem, because a people shaped by the government is the opposite of what we should have, which is a government shaped by the people.
Right. No, it's an incredibly powerful argument. Let's go back to Brown for just a minute. Could the opinion have been written without the discussion of government benefit? Or it strikes me that it actually, the government benefit actually here is very central to all of this. This was not, and I'm sorry to come back to common carriage, this wasn't a private transportation system. This was a government benefit. This is something so central,
right,
that the disparity becomes important when you have a government benefit like that.
Right. So I think when most people read Brown versus Board of Education, they look at it and they say the Equal Protection Clause of the 14th Amendment requires equality. Segregation was unequal. End of case. It's so easy. But that misses a lot of the history. So the Equal Protection Clause in the 14th Amendment is actually much more modest than people imagine. Equal protection of the laws was actually understood to stand in contrast to equal rights. That seems very odd. How could that be? There's a long tradition. It goes back to the 18th century, actually, disputes amongst religious groups. There was one ideal, which is that all rights, benefits, or constraints should be equal. And so so religious dissenters would say we want equal rights. But the established religious groups in 18th century America responded saying, well, you have a sort of equality. You have equality in your natural liberty to worship, but we get special privileges. And that's okay, because the equality guaranteed is equal protection of the laws. You have equally protected your natural liberty, but there is no equality in privileges, nor should there be. And in fact, that standard is written into 3 state constitutions: Maryland in 1776, Massachusetts in 1780, and New Hampshire in 1784. Those are the early equal protection clauses. This is understood in the 1860s when the 14th Amendment is drafted. Thaddeus Stevens doesn't want what we end up with in the 14th Amendment. He, the most ardent advocate of equality, proposes a constitutional amendment that would simply bar discrimination on the basis of race, period. It was about equality in all rights, privileges as well as constraints. That goes nowhere. Now, why does it go nowhere? There are good and bad reasons for this. One is it may be that there is still a fair amount of prejudice, even amongst many Northerners, and that's certainly true. But there's another thing to be considered, which is if Reconstruction is designed to include things like the Freedmen's Bureau and other systems of supporting newly emancipated slaves with some land so they can actually then support themselves as farmers, you have to distribute benefits unequally. So the 14th Amendment ends up guaranteeing only the equal protection of the laws. What that means for Brown is that there's a bit of a conundrum for the judges, which they clearly understood. If public education is a benefit, how can you explain why it has to be equal if the 14th Amendment really was about equal constraints, not benefits? And there's a clerk, Alexander Bickel, writes a memo on this that gets published in Harvard Law Review later that year. The solution is unconstitutional conditions doctrine, precisely that line I read to you. Such an opportunity where the state is undertaking to provide it is a right which must be made available to all on equal terms. Unconstitutional conditions doctrine is central here. You can't decide the case without it, at least if you're respectful of the history.
Wow, that's very powerful.
You know, no one wants to know this, of course, but it's right there in the case. And so the amazing thing is that the precedent on which the speech argument rests is Brown versus Board. And if you want to back away from the speech argument that public education is being offered on an unconstitutional condition, as an unconstitutional condition, you have to back away from Brown versus Board of Education. I don't think anyone wants to do that. This is the most rock solid foundation one can have for any claim about education. Who knew?
So tell us a bit about how the court, if the court were to address it, what are some of the avenues that it might take? What are the consequences of education as speech?
Right.
Those are the court.
I think it's a good question, isn't it? So at the outset, I should say, I'm not sure I want to take this up to the Supreme Court in any hurry, right? That's not one's only option. There are many possibilities. I don't want to lay them all out here, but one of them is, for example, to deal with this at a state level. States have free speech guarantees. Maybe some states should be asked to consider this issue before running off to federal courts. Now, what do you actually ask a judge to do? I don't think you're asking for a judge to say, oh, state, you now have to have vouchers or something like that. That's none of the business of a judge. I think what one wants is a very modest judgment, either declaratory judgment, at most an injunction, barring unconstitutional conditions in speech. And then the state legislature needs to have time to figure out what to do. And there are many possibilities. One would be simple tax relief. Another, at the other end of the system, would be vouchers, some sort of spending support that is more distributed, not just in support of state schools. And there may be yet other possibilities that we haven't thought about because we're just sort of academics, and people who actually make laws have a better understanding of the world. So who knows what may come out of this? Many possibilities. But what will happen, surely, or should happen, is that there'll be greater freedom for parents to use their own speech to their children and not be forced to adopt government speech.
Can you expand on this concept of parents and their role as sort of guardians of children, that the state recognizing that? Because the role of parents here seems to be very, very crucial.
Right.
Can you expand on that?
Sure. So there are layers to this, I think, and there's a vast literature on it. So at one level, before we even get to law, just as a matter of anthropology and sociology, or morals, if you want to discuss things folks really don't like to discuss, the children are under the tutelage of their parents, under their control. Not perhaps sufficiently, as any parent will know, but this is the government. This is the child's government, and that's a good thing because parents love their children more than others are apt to do, and understand them better. They live with them through good and ill. It's not as if some expert in government can really understand a child as well as a parent can. It doesn't mean one doesn't want sometimes help with parenting, but it's a very entirely different relationship than one has with government or experts or doctors or stuff like that. And so there's that's relationship, and I think anthropologists would back up those making moral arguments about the importance of parental authority here. I don't want to call it power, it's really about authority. Now, there's more to it, of course, because the law itself recognizes this. The law of custody is ancient and fairly continuous. Of course, the state can interfere in certain circumstances, but that's exceptional. On the whole, parents have custody of their children. It's a right and a responsibility. Add to that as another layer, the very law that requires parents to educate their children is a recognition of their authority, right? And then there's a constitutional layer here, or at least that layer of it which has been recognized thus far as constitutional in Pierce versus Society of Sisters, not to mention the Meyer case, in which the authority of parents is recognized as a substantive due process right by government. And whether that's really the appropriate foundation for such a claim, we can discuss. I'm somewhat skeptical of substantive due process, but there's clearly something going on here that is important. And it's good that the court recognized it, though how we categorize it is complicated. So it'd be very hard for any court to back away from all those layers. Parents do have authority here, and that matters because this is the speech of parents to their minor children that we're talking about.
Are there court cases, there are issues that come up when parents have their children in school about can they be excused from certain classes because there may be topics that are discussed that the parents don't approve of, or can they not attend certain school trips or events because they don't approve of them.
Right.
How have the courts addressed that when a parent comes to and doesn't approve of some school event or some part of the curricula? Have the courts been sympathetic to parents or not?
I have not dug into those cases yet, so I don't really know. But notice it's most of that is dealt with at a informally by the schools, right? It doesn't go up typically to a court case because schools usually are quite happy to accommodate parents on relatively minor things. And certainly when you're leaving the school, there are other set of issues there. So most schools actually have parents sign contracts giving up any claims against the school when they take the kids sort of out of school bounds. So where the issue really comes up is in classroom education. That's where one really has to worry about this. Now, the claims that are ordinarily made where one has a strong constitutional basis would be religious claims, right? A claim of religious exemption. Those flourished from 1963 to 1990 in the court, less so now, although there's now state and federal statutory protections. So don't really get to the constitutional issue typically. But notice that at least once the Supreme Court went much further than just excusing one from a particular class, and it was the Yoder case involving the state of Wisconsin. I forget when, someone in the 1940s. In any case, the state of Wisconsin required education up to 16, and the older Amish said, "Whoa, wait a minute, we'll educate our kids up to 15, but that's already, they really should be working then. You're not getting them at age 16." And the Supreme Court upheld the claims of the old order Amish. Interestingly, though, at the end of the opinion, the court says, but you other religious groups don't think you're going to get this sort of special treatment. The older Amish are very special. They take care of their kids. They're economically successful. We don't trust the rest of you with this. So is this a general rule? I have no idea. But it is important because it's again a recognition that government can go too far.
One of the issues that one of the concepts that you've pointed out in your discussion of this, though, is that if education is speech, then that's not something that's just reserved for particular religious groups or particularly religious parents, but it's something that's available to all parents.
Right.
This is independent of any religious foundation.
Right. So there's been a sort of a bit of a risk that the groups that get involved with these sort of questions are often religious groups with perfectly reasonable concerns about intrusions on their beliefs and training of their children, the risk is that they will see things in a religious perspective or have an agenda for a vision of religious liberty, which is fine, except that it's worth keeping in mind that sometimes the rights work together. It's not just one right we rely on. We rely on all of them. None of the substantive rights are of any use without the procedural rights and so forth. So in this instance, it's very useful to have a speech right, as it were, to come to the aid of one's religious concerns, because religious liberty may not protect one enough, even if one's a religious parent. Why is that? So for one thing, religious liberty claims only protect the claims of parents want to put their kids in religious schools or have religious training for them. It doesn't, and that's awkward because it doesn't really map onto the authority of parents. If you want to have a right that really tracks the authority of parents, which I think gives it much more heft and strength in legal argument, then you have to talk about speech rights. That does, because all parents, even if not religious, have speech rights. In other words, this is an argument in defense as much of atheist parents as any others, as much of radical communist parents as of conservative parents. There's no particular angle to this, nor should there be. And why does that matter? It's not just that it tracks parental rights. It also means that all parents can have an interest in this. In constitutional litigation and in just thinking about rights, there's a grave danger of chopping up rights into little pieces, which means you narrow the interest group, the sort of social support for the right. If you can state a right broadly, and the speech right is much broader than the religious right, then all parents can have an interest in this, even if they're loggerheads about politics, culture, or anything else. And there's been a particular danger in the free speech area. So, for example, think about businesses, 501c3s, religious organizations, political parties. They all have speech rights that are defined differently by federal law. They're chopped up into little pieces by tax law and other areas of law, so that if the speech rights, let's say, of churches are threatened, the political parties and the businesses say, meh, we don't really care. That's not our speech right. And when the businesses are attacked, the churches say, that's not really our speech right. You deal with that on your own. Nothing could be better for tyranny, right? The idea that you chop up speech rights is lethal for our ability to protect them. So it's very important to do a better job of recognizing the breadth of the rights being protected, because only that will secure them.
Wow. So there really aren't concepts of you have speech rights, the Syria law, and give them up in some other area or this context, that the speech rights are just fundamental and have to be.
Right. So I've dealt with this a lot in connection with 501c3s. 501c3 places restrictions on political engagement by what are they called nonprofits. Let's put tax language. What they really are idealistic organizations. Now, why would you want to suppress idealistic organizations more than business organizations or political organizations? Are ideals that dangerous? Apparently. So we use the tax law to suppress their speech. This is clearly unconstitutional, but very cleverly, the federal government places limits on standing, so it's actually very hard to challenge this in court. By the way, the two restrictions on speech in 501c3 basically on lobbying and election speech, they come from, they were first proposed in 1930 as a pair by a gentleman, it's the wrong word, not a gentleman, a man called Hiram Evans. He had a big wide smile, from Dallas, and he was very well known because he was the imperial wizard of the Ku Klux Klan.
Wow.
That's where this comes from. And it's designed to suppress the speech rights of churches, meaning the Catholic Church and any church with a sense of orthodoxy. Because the theory is, of course, that theologically liberal Americans can express themselves adequately through other organizations. And that's where our law comes from. Our tax law comes from the KKK. And by the way, Hiram Evans wasn't just an intellectual. He was, by the way, he's a very smart guy, dangerously smart guy. He gets attention in 1920 because he's a member of the Clavern that grabs a poor bellhop a black bellhop out of a Dallas hotel, drags him out to the river, whips him, and then uses acid to etch KKK into his forehead. I don't know for certain, but where dentists have a lot of access to acid. This is ugly stuff, and this is our law, and the Supreme Court has upheld this nonsense. What a country!
You've mentioned the Klan a couple of times, and I'm getting this eerie sense that the Klan was influential in the development of speech laws. And
so Hiram Evans has his office just at the southwest corner of Farragut Square. He's very connected to lots of congressmen. He makes himself socially available. He's a member of the Congressional Country Club, so he plays golf with them. And so it's no surprise that 4 years after publishing this stuff, Senator Reed from Pennsylvania introduces the beginning of what becomes 501c3 speech restrictions. And 20 years later, another Texan, LBJ, introduces the other speech restriction. We've had some pretty creepy elites. And so I don't want to say that this makes this unnecessarily unconstitutional. Hitler built good highways. That doesn't mean highways are bad, right? But it just should get one's attention enough to actually think about the free speech issue, just to reconsider it a bit. Right. I've sometimes wondered whether I should write a book called Nativist Jurisprudence, just so people get a sense of just the depth and how it's infiltrated our jurisprudence. I don't have time, but maybe one day.
It'd be a great book. But I'm just thinking about the contrast between the quote you gave from 1904 about education being this mill that produces homogenous citizens. And I'm thinking about your other subsequent comments about, well, parents, if they're, whatever their view is, they ought to be able to have control over what they ought to control what speech their children hear. There's which creates the exact opposite of homogeneity. You get heterogeneity. Maybe America is an inherently heterogeneous society. So there is this tension. And so you're saying our speech laws, or maybe more precisely our education, really began, or a lot of it is this homogeneous concept. And that seems to be a tension with the speech interests of individual parents.
It is entirely contrary. I think you're absolutely right. It's entirely contrary to the nature of our society. Our society from the beginning was diverse. Think about it. What does early America look like? Native Americans who were themselves diverse, settlers who are diverse. We might say, well, they're all white. Well, they didn't really love each other in Europe, right? And then people from all over the world. We are a multi-ethnic national society with a whole host of languages, and that's not a bad thing. So, around 1920 or so, at the beginning of the 20th century, 20% of Americans spoke German at home. My parents, when they wanted to hide some stuff from it, would speak German. Was that so bad? I don't think so. And what does it matter if one's speaking a Native American tongue, if one's speaking in Eastern European tongue, if one's speaking Mandarin? Who would care? In fact, one should care because this is good. It enriches our lives, right? Diversity doesn't just consist of different flavors at restaurants. I can get some Chinese food. Well, that doesn't cut it. There's a lot to be learned from Chinese culture and language, which we could actually take seriously intellectually, and Latin and Greek, and then of course the German and the French. And why are we throwing this away? And I think we have an educational establishment that just cannot bear the sheer variety that we bring to the table. And by the way, in current politics, I cannot overemphasize, this is not a critique of people who have radical views. On the contrary, we should recognize that we all have a right to what John Stuart Mill called to an experiment of living. Let's try out different things if we want. I'm not going to agree with what everyone else does. I disagree with what most people do. And vice versa, and that's fine. That's just fine. We shouldn't get anxious about difference.
Is the First Amendment a uniquely American ideal? I mean, other countries may not have the same protection of speech and therefore might move more towards the homogeneous mill of education. Is the First Amendment sort of uniquely American in that way?
Well, I wish. I could throw it away. The commitment to accept, it's one thing to say, you're free to speak and we'll disagree. We can talk about it or not, but I'm not going to prevent you from speaking. And to say, we're free to speak and that's okay, as long as you don't go outside these boundaries, which I've set for you, which are remarkably close to my own views. And that seems to be increasingly the expectation about speech in this country. So I do think we have the advantage of having a constitutional amendment to argue from. That's a great, great blessing. But it's already an uphill struggle, right?
Yeah, no, it is an amazing. Can we touch just briefly on the intersection of education with high tech and First Amendment?
Can I? Yes, but I just going to I forgot one thing I want to throw in there. So I grew up partly in England, and there used to be a lot of free speech, not because of social diversity, but because of an acceptance of eccentricity, an acceptance of differences in manners amongst an elite. That was one angle in this. Ours has been social diversity. Maybe neither are enough to resist the forces of conformity, but we'll see. Sorry, but let's go back to yes, let's talk about high tech.
No, before that, I've noticed the same thing in British academia. What is acceptable scholarship is a much broader range than American academia.
And by the way, I think this is true amongst elites everywhere. So, I mean, for example, in Pakistan, I think this is true. In certain circumstances, there's extraordinary tolerance. In other circumstances, less. And one of our dangers in democratizing education is to bring the expectations of conformity that a mob might have into the realm where people might have civilized disputes. We'll see.
Okay, briefly on high tech. I know you've been doing some thinking about that as well. Any thoughts you want to share with us about it?
No, there's too much to talk about.
Too much, okay.
Well, look, the large social platforms, interactive service providers, systems, they've created a mode of communication that is immensely valuable. They've done extraordinary things, and all of this is admirable and desirable. At the same time, however, we have to recognize that they fall into a pattern that's familiar across our legal system for a long, long time, which is that they are common carriers. They also fall into a category known as the public forum, but we need to go take that route. They serve as common carriers. And what that means is, of course, is they're subject to regulation to bar discrimination without running into the First Amendment. Common carriers, including information common carriers, have been regulated to prevent discrimination for ages. Telegraph, telephone, radio, blah, blah, blah. You can say each time the folks in the technology say, no, we're different. The people in telephone said, we're different. We're not like telegraph. And the folks in radio say, no, we're different. This is entirely different technology. This is not telegraph or telephone. And so now they're saying, oh, no, this is different.
Yeah.
Of course it's different, but in some ways it's the same. And so they're subject to regulation. So there's a Texas statute which among other things, HR 20, which bars discrimination, viewpoint discrimination by social media platforms. This is perfectly constitutional. This is actually protecting freedom of speech because it's regulating them in their function as conduits, not in their speech. When you serve as a conduit for speech open to the public, it doesn't matter if you try to exclude people, that doesn't justify further discrimination. If you're serving this function, and especially if they're this large, it's quite clear that you can have this sort of regulation. It's perfectly constitutional. And so hopefully other states will be adopting similar such statutes, and we'll have a realm of free speech, at least in those states in this country.
Well, Justice Thomas, last spring, issued a statement questioning whether social media platforms were in fact common carriers.
His opinion suggested that they can be regulated as common carriers, and that's you might say it's jumping the gun, but he was just reciting standard doctrine. There was nothing novel about this. And I must say, I didn't get into this because of any desire to do tech law or that. It's at least my interests. But at a meeting of religious minorities, was it 4 or 5 years ago, one young lawyer there, very smart young lawyer, approached me and said he thought he was thinking about trying to sue to protect people's free speech, but he didn't know how to do it. He asked me to undertake it. Well, it was sort of entrusted to me as this gift I didn't want. And so for a while I thought, what am I going to do with this? But then I thought, okay. And interestingly, so I tried to pursue this litigation. And what was revelatory was the degree to which almost every large law firm in this country has tech money or wants it, which means you have a conflict of interest in every firm where you might have hoped to find some depth of personnel to conduct such a suit, because this is not a small undertaking. I won't give you all the details of that. It's grim. Suffice to say that after a while, I realized enough of that. It's much easier just to draft a statute and hand it off to any state that's willing to try it. And that's what happened. I drafted an anti-discrimination statute. Texas was one of the states that picked it up. They played with it a little bit. It's not exactly, they added some stuff and so forth, which is fine. And we'll see what happens. And now there's litigation, the net choice litigation, to see what happens. But all of my interest in this, including this statute, anti-discrimination statute, comes out of trying to protect minority churches, including Black churches. The degree to which people with deviant points of view, i.e. just traditional churches, consisting of small numbers of worshipers, are at risk from all of this is very high. People don't really realize how much it just crushes people's hopes to espouse what they think are perfectly reasonable points of view, and usually are.
Well, Professor, this has been a delightful conversation. Thank you very much for joining us today, and we look forward to welcoming you back to Hudson in the near future.
Thank you.
With that, we'll conclude, and I hope I can continue this conversation afterwards.
Thank you.